and esteemed member of the bar. Good evening to you all. On behalf of Telangana High Court Advocate Association, I extend a warm welcome to Honorable Sri Justice Abhay S. Oka, former Judge Supreme Court of India Garu, Honorable Justice and other judges. We also extend our cordial welcome to Advocate General A. Sudarshan Reddy Garu, Chairman Bar Council of Telangana A. Narasimha Reddy Garu, Additional Solicitor General of India B. Narasimha Sharma Garu, Additional Advocate General Sri Muhammad Imran Khan Garu, Additional Advocate General Sri Tera Rajnikant Reddy Garu, Deputy Solicitor General of India N. Bhujangrao Garu, Vice Chairman of Bar Council of Telangana K. Sunil Gaur Garu, Member Bar Council of India Sri P. Vishnuvardhan Reddy Garu, and Public Prosecutor Sri Palli Nageshwara Garu, and along with all the senior advocates and respected members of the bar. On behalf of Telangana High Court Advocate Association, I heartily welcome you all to the special gathering organized for the lecture on problems the judiciary is presently facing and solution to cure it. We are deeply honored to have among us Honorable Justice Abhay S. Oka, former Judge of Supreme Court of India, who has experience and profoundly insight continue to guide in and inspire the legal fraternity across the country. This is the timely and important discussion, and we look forward with Justice Oka's thoughts on the challenge facing our judiciary system today and what we can overcome them. Now I invite our President A. Jagan Garu to order the chair and the dais. Now I request Honorable Justice Nanda Ma'am, please order the chair and the dais. Now I request Executive Committee Member Kalia Naresh to honor and present the bucket to Honorable Judge Nanda Garu. Now I invite Honorable Justice Abhay S. Oka, former Judge Supreme Court of India, and order the chair and the dais. Now I request our President to do the honor and present the bucket to Honorable Justice Abhay S. Oka, former Supreme Court. Sir. Now I request Vice President G. Rajeshwar Reddy Garu, Telangana High Court Advocate Association, to kindly grace the chair and the dais. Now I request our Secretary Indra Reddy Garu, Telangana High Court Administration, kindly grace the chair and the dais. Now I request our Honorable President Jagan Garu to preside over the function.
Good evening, everybody, my brother and sister and senior advocates. Honorable Chief Justice, Honorable Justice S. Abhay S. Oka, former Judge of the Supreme Court of India, on behalf of the Telangana High Court Advocate Association, I heartily welcome you, sir, to give a lecture on problems the judiciary is presently facing and solution to cure it by the Honorable Justice Abhay S. Oka, former Judge of Supreme Court of India. Honorable Justice Abhay Srinivas Oka was born on May 25, 1960. He completed BSc and LLM from the Mumbai University. Justice Oka enrolled as an advocate in Mumbai in 1983, started his career at the Thane District Court in his father's chamber. He then joined the chambers of the Senior Council for the Union of India, VP Techniques, in 1985. In the year 2023, he was appointed as an additional judge of the Mumbai High Court and subsequently made a permanent judge in 2005. For the last more than 13 years, he was appointed 13 years in judicial service, and then he was appointed the Chief Justice of the Karnataka High Court in 2019. Before elevating as a Judge of the Supreme Court on August 17, 2021. During his tenure as a judge of the High Court, he passed many orders on the environment protection and benefiting conditions of the movement. And during his tenure as a Karnataka High Court judge, Justice Oka authorized the judgments on the case pertaining to the vaccination. The state government was directed to provide individuals with the disabilities according to Section 25 of the Disabilities Act. The judgment also provided guidelines to the relevant authorities. In the case relating to monkeys death in Vellore Taluk, as reported to the several newspapers such as National Herald and other all papers, the Chief Justice of Oka, along with the ASSN Sanjay Gowda, emphasizes that need to establish guidelines to prevent future incidents of the animal cruelty, which were both inhuman and shocking. And after elevation to the Supreme Court, the Honorable Justice Oka on personal liberty in respect of PMLA, a bench including Justice Oka ruled that the Enforcement Directorate cannot arrest the accused under the PMLA after the special court taking the cognizance on the complaint, reinforcing the proclamation safeguard against the arbitrary arrest. On freedom of speech, Justice Oka was the FIR a professor who criticizing the abrogation of the Article 370. Justice Oka authorized the judgment. Every citizen has the right to offer criticism. If every criticism or protest or action of the state is to be held as an offensive, democracy will not survive. And on UPA, interpretation while granting a bail in an UPA case is a judgment made a crucial distinction between the more association with the banned organization and association with the internal to the further activities, preventing the misuse of the stringent law. And on right of the Anganwadi workers, he was part of the bench that held by the Anganwadi workers are entitled to gradually recognize the significance of the workers and their rights as employees. And other so many judgments with lordship is authorized, and more particularly with lordship's judgments on personal liberty. And I request the members to applaud his lordship accepting our invitation and to address our bond on the present situation where the judiciary is facing. I want to give, I request the Justice Okaji to address the problem and also resolutions and also how to solve it. Thank you very much. Now I request Justice Nandana to say a few words in respect of the Justice Abhay.
Respected Honorable Judge, Supreme Court of India, Honorable Justice Oka garu, Abhay S. Oka garu, respected President of the esteemed Bar Association of Telangana High Court, Jagan garu, respected Secretary, the two secretaries sitting on the dais, Vizara Taligaru, Sena Reddy garu, and also Rashik Reddy garu, and all the senior designate counsel sitting here, all the respected advocates, respected elders of the bar sitting here. I am happy to be the part of this momentous occasion where our esteemed Telangana High Court Advocate Association has invited respected Honorable Justice Abhay Oka Garu for this lecture on the topic, the problems the judiciary is presently facing and solutions to cure. We are all eagerly waiting, sir, to hear you on this interesting topic, which in fact is the need of the hour for us as judges to understand and also discuss the various ways in solving the issues which the present judiciary is facing. As judge of Telangana High Court, on behalf of all the judges of our High Court and our Chief Justice, Sri Abhish Kumar Singh, I thank you for accepting the invitation of our Bar Association, and I have kindly consented to come all the way from Delhi to our Hyderabad High Court and give you a valuable lecture on this important topic. We all look forward to hear from you, sir. I once again thank you sincerely and request you to address our High Court Advocates Association on the topic for today.
Now I request the advocates from the Hyderabad Commissioner who want to felicitate Justice Abhay S. Oka. Now I request President Hyderabad Uma S. Lakshmi and Ram Gopal Reddy. And also members from the Hyderabad, Sangareddy and Rangareddy. Please, all should come, please.
Sir, one group picture. Ma'am, కొంచెం దగ్గర మేడం కొంచెం ఫ్రంట్. Yes, okay, ready. Sir, 1 second. Yes, ready. Smile. Thank you.
Advocate Prasad and Ali, Honorables.
సార్ ఇక్కడ చూడండి సార్. రైట్.
I request you also may accept the felicitation on behalf of the Telangana High Court Advocate Association. Now I request by all members, please come on the dais and felicitate the Justice S. Abhay.
Sir. Yeah, madam. Yes. Okay, ready. Smile, smile. Ah. Yes. Wait. కొంచెం నవ్వుతే బాగుంటుంది.
Now I request Justice Abhay S. Mokaji to address our members on the topic. Now request.
Good evening. Sister Judge of Telangana High Court and the judges of Telangana High Court, Mr. Jagan, the President of the Telangana High Court Advocates Association, his colleagues, officers, senior members of the bar, and ladies and gentlemen. It is a great pleasure for me to be here in this historic High Court. This High Court has its own glorious traditions, it has its own great judgments delivered by this court. In fact, I can say that I have indirect connection with this High Court because my wife's paternal grandfather, Justice Vipulka Pandikar, was Chief Justice of Hyderabad High Court in 1955. The topic given to me today is very important. The problems the Indian judiciary is presently facing its solutions. On 26th of January 1950, the Constitution of India came into force, and all courts which are working or which are established under the laws of the British government, they started working under the Constitution. We know that there is a chapter in the Constitution on Supreme Court and High Court. But we ignore that there is also a chapter, there are also provisions in the Constitution on our district and trial courts, starting from Article 233. The Constitution deals with appointment of judges of the district court, appointment of other judges of the our civil and criminal courts. So in that sense, Constitution includes our district and trial judiciary as part of the constitutional setup. During last 75 years, we can say that there were certain great achievements by the courts in India under the Constitution. Today, of course, is not a day to discuss that, but briefly I refer to only one judgment of the Supreme Court, that is in the case of Keshavananda. And this is one judgment which has preserved democracy in India. Today, if we look at our left-hand side and right-hand side of India, or even on the northern side, we realize the importance of having democracy in India, and that democracy was saved by this one judgment of the Supreme Court, the majority rule in the case of Keshavananda. There are young lawyers here, they may not be aware that delivering judgment in Keshavananda was not easy. 3 judges who were part of the majority had to pay price for that. They were Justice Hegde, Grover. There are 3 judges, in fact, there were Hegde, Shelat and Grover. They were superseded 3 days after the judgment in the case of Keshavananda was produced, and all 3 of them lost chance of becoming Chief Justice of India, and they had to step down. So 3 judges had to sacrifice their career for the sake of upholding democracy in India. There was a 4th judge, one of the greatest judges, Justice H.R. Khanna, who delivered a very landmark minority judgment in the case of ADM Jabalpur versus Shukla. Those who have read his autobiography, they will know this, but I am telling this for benefit of young members of the bar. After Justice Khanna wrote his opinion and forwarded it to the other judges who had taken contrary, he went to Haridwar with his wife and sister. And while sitting on the bank of Ganges, he told his wife and sister that he had written an opinion which is going to cost him post of Chief Justice of India. And eventually he was superseded and he had to also step down. So we have great judgments, we have great judges who sacrifice their career. Today, when it is said that some of the judges are willing to make sacrifices for reaching higher position, we have these glorious examples of the judges who sacrifice their career for delivering landmark judgments. During last 75 years of existence of our constitution, I think one mistake which we committed where we have gone wrong is that we did not give importance to our trial and district judiciary. In fact, I have said so repeatedly during my tenure as a judge that calling any court as subordinate court or lower court is completely against ethos of our constitution. All courts are court, and therefore some of you may be aware that as Chief Justice of Karnataka High Court, I passed an administrative order that no court will be referred as a lower court or subordinate court. Because these courts are also working under the Constitution of India. In fact, in Supreme Court also, when we used to get report of the registry that lower court record is not received. So I said, now we must call it as trial court record and not lower court record. So these are the courts of common man. And unfortunately, during last 75 years, we neglected those courts in the sense that whenever there were seminars or workshops of bar council or advocates, we always discussed high courts and Supreme Court. We never discussed our trial judiciary. And today, if you look at the data available on National Judicial Data Grade, you will find that in India, in our trial and district courts, which include, of course, both civil and criminal courts, there are 4.72 crore cases pending in our trial judiciary. And the contribution of Telangana is 9,66,000 cases. Our trial judiciary has 9,66,000 pending cases. And out of which about 6.27 lakhs are the criminal cases. If you look at the High Court, total pendency in India in all High Courts is about 63.65 lakh cases. And as far as Telangana High Court is concerned, the pendency is around 2 lakh cases. But the worrying part is that 40% of those cases are 5 years old cases. This data is available on the website of National Judicial Data Grade. Now, firstly, I will take the first point, what really ails our judiciary. The first is, we don't have adequate number of judges in our trial and district courts. In 2002, Supreme Court delivered a judgment which refers to what is known as to population ratio. In various developed countries like America, Australia and other countries, the judge to population ratio was something between 75 to 120 or even more. So in 2002, Supreme Court directed that within 5 years, effort should be made by Government of India to enhance the judge to population ratio to 50. So the direction of the Supreme Court was that by 2007, there should be 50 judges available for population of 10 lakhs. And today, just see the scenario which we are facing. On 9th of February 24, the Honorable Law Minister gave answer on the floor of the Parliament. Now he said that the judge to population ratio in 24 was 21. And there is fallacy in this answer because while calculating judge to population ratio, he calculated the census figure, he calculated on the basis of census figure of 2011. He did not calculate it on the basis of population of 2024. In fact, on the basis of survey conducted by one of the organizations, there was a report in Economic Times in April 25, which says that for approximate population of 140 crores, we have 21,085 judges in our trial judiciary. So the judge to population ratio is only 15. Now today in some developed countries, it is more than 100. So judge to population ratio in 2007 ought to be 50. Now today we are struggling at 15. And we are talking about direction of the Supreme Court in 2002. And thereafter there are new category of cases which are being filed. The Domestic Violence Act came, then there was 138 of the Negotiable Instruments Act, there is IT Act. So there are a number of new enactments under which large number of cases have been filed after 2002. Now today we have a scenario where average number of cases assigned to each trial and district court is 2,200 per judge, which is physically impossible for any judge to handle this kind of a file. Of course, I must say that in some of the states in India, this figure of 2,200 crosses 10,000 per court. So this is the situation. So today, the first issue which we must deal with is increase the judge to population ratio. We should have at least 50 judges per population of 10 lakhs. But none of the states have taken any initiative. In fact, there was one more order of 2017 of the Supreme Court which directed all high courts to calculate what should be the ideal judge strength of our trial and district court and to submit a proposal to the state government. That was a direction issued by a bench of Justice Chandrachud. All high courts, I am sure that High Court of Telangana must have also submitted a proposal. I was chairperson of the Case Management Committee of Bombay High Court, and we calculated required judge strength. We calculated required judge strength of Maharashtra judiciary. Additional judges, we submitted a proposal for creating 8,000 more posts of civil and district judges in the state of Maharashtra. That was in 2017. Now today in 2025, I am told that even not even 10% of 8,000 posts have been created. So today our trial courts struggle because we don't have adequate number of judges. And we must remember one thing, that trial and district courts are the courts of common man. There are very few people who can afford to go to High Court or Supreme Court. There are many litigants for whom our district judiciary is the last resort. And they are all suffering because of inadequate judge strength. There is only one, when I say where we are going wrong, there is only one improvement which I see. Today, I am talking about figures of 2024. Out of the judges appointed in our district and trial judiciary, 38.3% are women. And this percentage was 30% in 2012, which has gone up to 38.3%. And now in many states during last 3 years, when new appointments to the post of civil judges was made, the percentage of judges exceed 50%. In fact, I am told today in Karnataka judiciary of trial court and district court, 44% of the judges are women judges. So this is one area where actually we have made some improvement. The second area where we have gone wrong according to me, which I said is one of my judgments also, that is in our judiciary there is lack of priorities. We don't have any rational policy or rational norms which will tell us which category of cases should be given priority. You know, there are statutes like Domestic Violence Act or Negotiable Instruments Act, many of the New Marriage Act, which require cases to be decided within a particular time bound frame, maybe 6 months or 1 year. Otherwise, we don't have a rational policy which cases should be given priority. There are provisions in POCSO also about the time limit. Now, we have a direction of the Supreme Court on the administrative side that cases of senior citizens should be given priority. Now, the age of senior citizens in India is 60. According to me, that direction requires recall. I will give a simple example. As a judge of the Bombay High Court for a long time, I have decided on bench dealing with family court appeals. So lawyers used to make an application that, sir, the respective ages of the litigants in family court appeal were more than 60, therefore give priority. I used to always tell them that if priority is to be given to matrimonial cases, it should be given to the matrimonial cases of parties who are in the 30s or 40s. Why should we give priority to somebody because he is above age of 60 years? Take for example, any high court, second appeals under section 100. In almost all leading high courts in India, second or third generation litigants are prosecuting, either prosecuting appeal or defending the second appeal. Now, whether priority should be given to such cases where third generation litigants is still prosecuting the cases, or because somebody is more than 60 years. So, we completely lack policy of giving priorities. And I must say with great responsibility, because I have said so in my judgments also. Our higher courts, that is the High Court and Supreme Court, also created a problem. That problem was of issuing directions to various courts to decide cases within 6 months, 3 months, 2 months. In fact, now I am party to a judgment of the Constitutional Bench which lays down that High Court and Supreme Court should not fix time-bound program before any court, unless the case is an exception. The reason is that when I sit in the High Court, I want to reject a bail application, but I want to at least create a show that I am giving some relief to the applicant. Therefore, I say decide the trial within 6 months. When I say so, I don't know what is the pendency in that particular court. When I say that a trial of 2022 should be given priority, maybe in that court there may be more trials pending from the year 2012. Now, this sort of directions issued by the High Court and Supreme Court created serious difficulties. I remember there is City Civil and Sessions Court in Mumbai. I was guardian judge or administrative judge as in some other high courts it is called. So judges used to complain to me that, sir, some judges used to say, sir, I have 60 or 70 cases where the direction of the Supreme Court or High Court to decide within 6 months, how do I manage it? And therefore now we have judgment of 2024 of the Constitutional Bench that unless circumstances are exceptional, no case should be expedited or time-bound program should be fixed. Because reason is that every court is independent court. A district judge or a civil judge for that matter and magistrate, only he knows what is the pendency of cases before him. Only he knows which cases should be given priority. Judges sitting in other courts do not give those directions. In fact, I always give example of a case of Bombay High Court. I was presiding over a division bench of the Bombay High Court, and our bench had passed some interim order or ad interim order, and we had kept a case for hearing on the prayer for interim relief. So I received an order from Honorable Supreme Court stating that High Court will hear and decide the case on the same day, writ petition. And by the time that order was received and the case was actually fixed for hearing on prayer for interim relief, it is typical Bombay case. So there was a counter affidavit running into, say, about 3,400 pages. So 17 volumes of 200 pages. Then there were 15 volumes of 200 pages of rejoinder and surrejoinder, etc. So I told the lawyers that now this is the order. So I requested the Chief Justice to provide me staff even after 5 o'clock so that I can continue till midnight. But both the lawyers said, no, we'll seek clarification from the Supreme Court. And therefore matter, I recorded that we are willing to hear it, but lawyers are not ready. So this situation is created, this sends wrong signal. Otherwise, some litigants carry the impression that if you go to higher court, say like High Court or Supreme Court, engage a senior lawyer, and then you walk away with an order that case, higher court should give priority or High Court should give priority to a case, and case should be decided within 6 months or 8 months. So this is one area where we have committed mistakes. And now, of course, there is judgment of the Constitutional Bench, but even after judgment of the Constitutional Bench, I find some judges of the High Court passing these orders that decide a case within 3 months, decide a case within 6 months. Now, when we pass such orders, we don't have data with us sitting in High Court that what is the pendency in a particular court, what cases are pending, how many partnered cases are there in that court. So this is one area where we have really gone wrong. There is a third area. Now we have reports of what we call it as National Level Court Management Systems Committee. We don't have a proper case management system. Now what is case management? Now to have a proper case management system, we should have priorities. Which cases should be given priority? And we lack in case management system, and therefore in trial courts we have a scenario where on one day about 10 suits or 10 criminal cases are kept for hearing and 20-25 witnesses are called because we don't follow the case management system. For last 12 or 13 years I have been teaching various judicial academies. So I deliver lectures on how to manage the causes. So we have a scenario where 20-25 witnesses are called and those witnesses go back without their evidence being recorded. In fact, I always tell the judges in judicial academies that we must make a distinction between the parties who are witnesses to the proceedings and the witnesses who are not parties. So we summon the witnesses, witnesses come to the court and they go back. I will tell you a very interesting incident. In city of Mumbai, there are two national highways which pass, Eastern Express Highway and Western Express Highway. So there are a large number of accidents. Bombay is the only city where there is separate motor accident claims tribunal consisting of about 8 to 10 judges. So I was administrative judge of that tribunal, and we have to hold loka adalats. So some lawyers of the insurance company came to me. They said, sir, in almost all injury claims which are made in that motor accident and tribunal, the accident used to take place within the limits of Greater Mumbai. The disability certificates are given by only 5 to 6 doctors in the city. So we must, how insurance company can rely on these certificates. So I went deep into it, and then I was told that there are many eminent orthopedic surgeons or surgeons in the city who treat the accident cases, but they refuse to give certificates because they are worried that they will be called to the court and repeatedly they have to come back without recording their evidence. So this is one area where we are lacking is proper case management techniques. It happens in criminal cases. There are many, in fact, when I started practice, for 2 years I practiced in district court. In those days, not only in Maharashtra, but I know of some certain other states, the practice was that a sessions case, the hearing used to commence on Monday and used to go on day-to-day basis. Witnesses were never sent back, at the most they were called on the next day, the succeeding day. But now today we have a scenario where, witnesses come and go. So this happens because of lack of case management techniques. And there are a number of reasons why, now I am on basically on criminal trials, why the cases are delayed. There are many states where there are no public prosecutors appointed. There are many states where for 3 criminal courts there is 1 public prosecutor. So trial can take place on a particular day only in 1 court, and other 2 courts keep on adjourning the matters. So we don't have adequate number of public prosecutors who have been appointed. Now this is one area where I don't know whether how many of you are aware. In 2023, Supreme Court prepared guidelines for the benefit of our district and trial courts. There is an action plan, and there were directions issued phase-wise that firstly there should be physical verification of cases, and then all identified old cases should be disposed of in a time-bound program. And I was as the chairman of that committee, I used to hold monthly meetings of the judges of all the high courts, where we were actually implementing that action plan. And while implementing the action plan, we suggested to all the high courts that wherever there are adequate number of prosecutors are not appointed, please do the government and ensure that prosecutors are appointed. And not only that prosecutors should be appointed, prosecutors should be paid properly. There are many states in India where for years, for months, the prosecutors and government advocates are not paid their bills. I remember a case in Maharashtra. A very, very eminent district government leader was known for his honesty, integrity and competence. He was not paid his bills even in land acquisition cases where he must have saved lakhs of rupees of the government. And then he had to file a suit. After suit was filed, government still did not pay, did not file appeal. So ultimately in the execution proceedings, the chair and car of the district collector was attached, and thereafter he was paid his fees. So this is a scenario happening in many states that if the government advocates and the public prosecutors are not paid on time, how they are supposed to work efficiently. And they are the ones who conduct very sensitive cases. Now, for example, public prosecutors, Now they deal with very sensitive cases which are sensitive to the society. Society at large is affected because of our decisions in the criminal cases. So that is one area where we are really going wrong, and we don't have adequate number of public prosecutors. In some districts in some of the states, even the government leaders are not there. So even civil cases where government is a party cannot be conducted efficiently. So we need to work on that. There is one more area where actually we are gone wrong. I am on procedural aspect, and then I will come to the other major aspects where members of the bar have to play a role. We brought in one amendment in 2002 to Civil Procedure Code where we permitted examination in chief to be recorded in the form of affidavits. In all leading cities, what is happening is there are bulky examination chiefs because now there is no limit on that. Lawyer dictates in his office and dictates a very long examination chief. Had the same examination chief been recorded in the court, perhaps it would have been very short. But now we have very bulky examination chief in the form of affidavits, and because we have very bulky examination chief, very lengthy examination chief, we have a very lengthy cross-examination. Same thing is happening in prosecutions under section 138 of the Individual Disputes Act. The complaint runs into 10 pages or 6 pages, but the examination chief of the complaint runs into 25 pages. Now this is one area where, the provisions of the statute have been misused, and instead of curtailing the time of trial, it has actually contributed in delays. And there is one more area which I will come to later on. That's the role of the lawyer. There is one more important area which is the main reason why now there is huge tendency. You go to any important city, any leading city in India, during the last 10 years, you will find that the matrimonial disputes are on rise. Because of the changes in the society, there are a large number of matrimonial cases, and look at what is happening. I used to sit in Supreme Court and hear those transfer applications of transfer of matrimonial cases. Now, if there is one matrimonial dispute, there is one litigation say under the Hindu Marriage Act or Special Marriage Act for divorce, or there are multiple litigations. Husband files for divorce, wife files for restitution of conjugal rights. Then there is a complaint under old 498A. Then there are proceedings under section 125 for maintenance. There are proceedings under the Hindu Adoption and Maintenance Act. If there is a child, which is very unfortunate in matrimonial dispute, then there are proceedings filed for custody of the child. Then there are proceedings under the Domestic Violence Act. And now latest, which I came across was, because of this WhatsApp, now the husband or wife files criminal complaints under IT Act on the basis of WhatsApp conversation, WhatsApp messages which are exchanged. So one matrimonial dispute is creating 4 to 5 or even more cases at grassroots level. And then there are revisions, there are writ petitions up to SLP. So this is one category of litigation which is actually threatening the entire judicial system. And therefore we should have a robust network to ensure that these matrimonial matters are settled at the threshold. In fact, in Bombay, we tried with one more option. We set up a center under the title Let's Talk. We appointed counselors and we requested the police that whenever a woman comes to the police for filing complaint against husband and in-laws, the police should request the lady to come to the high court, and then we used to call these spouses and try to work out a settlement even before the parties go to the court. So in many cases we ensured that a reconciliation. In many cases we ensured that parties had golden handshake and they actually filed a petition under section 13B or any other statute providing for divorce by mutual consent. So matrimonial litigations is one category of litigations which is now threatening the entire legal system. And these are reflections of the society. I always tell my judges in the judicial academies that if there is one matrimonial dispute, 3 families are vitally affected. One is the small family of husband and wife, and if there are children, that includes children also. Then the family of the wife, the parents and other family members of the wife, and parents and other family members of the husband. So 3 families get affected because of one matrimonial dispute. And matrimonial disputes, if you don't settle at the threshold, it has potential of developing into 25-30 cases at different levels. And if you don't settle the cases at proper time, then the bitterness increases between the parties. And then after lapse of 5 or 6 years, after the cases are filed, one party says, no, I want to teach lesson to the other spouse. So the party is not willing to settle. So this is one area where we have to really work hard. The other area where actually legislature has to step in is about section 120 of the Negotiable Instruments Act. Cases where normally person can't go to civil court and recover money, those cases are now taken to the criminal court, and how much time those cases are consuming on the courts, all of you know. There is one more area where actually we need to work hard. The members of bar and judges have to work hard. Before I deal with that, there is one more issue which is faced by many courts in our India. That is lack of adequate infrastructure. There are many district and trial courts where there is no proper infrastructure. Judges don't have proper place to sit. Litigants do not have place to sit. Litigants don't have proper elementary facilities like clean drinking water, washrooms, etc. Many courts across India, they don't have this adequate infrastructure. We are lagging far behind when it comes to the infrastructure. In fact, it is a duty, in fact there are judgments of the High Courts and Supreme Court will lay down that it is the constitutional duty of the state government to provide adequate infrastructure to the courts at all levels. Talking about one of the bigger cities in Maharashtra, I'll give you an example, city of Pune. Now city of Pune, Pune district has one peculiar feature. It is the largest judicial district in the entire country. It has more than 250 judicial officers in the district. But if you go to civil court in Pune, there are 10 senior civil judges who don't have separate chambers and courtrooms. They sit in a room. After 11 o'clock, that room is before 11 o'clock, and in the recess, that room is the chamber of the judge. And after 11 o'clock, it is treated as a courtroom. So you can find we lack elementary infrastructure, and elementary infrastructure has to be provided to our trial and district courts. Only in one area there is an improvement, I must say that. Now, as far as our trial court judges are concerned, now they are being paid reasonably. When I joined practice in 1983, the judges were not given even rent-free accommodation. 10% of basic salary was deducted from their salary, and those were the days when judges of the trial court and district court, they could not afford to buy even a two-wheeler. Now things have changed. Now the remuneration which a civil judge gets at the age of 27 years or 26 years, he gets, after deduction of income tax, he gets 95,000 as a salary, plus all the purpose in rent-free accommodation, then driver allowance and children's education allowance. Now in fact, now there is a grievance by IAS and IPS lobby that a young IAS or IPS officer is paid much less than what a civil judge gets. I remember when I joined practice in 1985 in High Court, the salary of the High Court judges was 3,500, which was the salary payable in 1862 when East India Company handed over power to the British government. So for more than 100 years, salary of High Court judges continued to be 3,500. And those were the days when even cars were not provided. I have seen in Bombay High Court, the judges have those Fiat cars and they used to have carpool. So 4 or 5 judges used to travel by car up to the High Court where even cars were not provided. Now there also now, I think better salary and perquisites are available. This is one area of improvement which I see during last few years. In fact, I remember there was a function in Bharatiya Vidya Bhavan in Mumbai, which was addressed by, I was a student at that time, addressed by great lawyer Nani Palkiwala. And I distinctly recollect Mrs. Margaret Thatcher, who had deputed office as Prime Minister of England, she was also invited. And in his speech, Mr. Palkiwala told Mrs. Margaret Thatcher that when Britishers started ruling India, High Court judges were paid salary of 3,500, and even it was in 1980-81. Even on that day, the salary was 3,500. For more than 100 years, salary continued to be the same. So this is how the judges were treated. Now, of course, I must say that there is a great deal of improvement in that area. Now, I will come to the very important issue of saving the time of the court. Before that, I must say that we have not realized one thing, that court time is very precious. Every single minute of the court is important. but we don't try to save the time of the court. Of course, in later when I must say that as a judge of the High Court and Supreme Court, I have my own ideas of saving time. So I did not allow lawyers to argue beyond a particular point to save the time of the court. But now what is happening, I tell you, we see very lengthy cross-examinations. I was reading a bench in Supreme Court. We came across a case where one witness was under cross-examination for 94 days. 94 days witness is being cross-examined. Because now art of cross-examination is being forgotten. Now what is happening is in civil court and criminal court, the lawyers give suggestions in the cross-examination about every sentence in the examination chief. I put it to you that what you have said is not correct, XYZ is not correct, ABC is not correct. In fact, that is not a cross-examination. You need not give suggestion to the witness that everything he stated in the examination chief is untrue. Ultimately, the purpose of the cross-examination is to ensure that the witness loses credibility in the eyes of the court. Ultimately, you have to prove before the court that his witness is not reliable, but it is bulky cross-examination. And lawyers, the judges are not able to stop the lawyers. Because sometimes lawyers become very aggressive. There is one more, you see, sometimes the technology has helped us. Only because of our technology, our courts could function in the pandemic. But sometimes wrong use of technology creates a huge problem. When I became a lawyer, we were told by our seniors to make research to find out case law on a particular topic. So in those days, we had to go through several commentaries, pull out those commentaries physically, make a physical noting of the citations mentioned. Then we had to go through those digests, AI digests, and there are so many digests in those days. So we used to make copious notes, and after writing down those citations, then we had to go to the law reports and find out whether what is mentioned in the commentary or the digest is correct. Because sometimes what was mentioned in the commentary and digest used to be incorrect. So the research used to take so much of time. When I joined practice, it was not possible to prepare photocopies of these bound volumes of AI, Supreme Court cases, etc. So we used to physically carry those books to the court. And since we are required to physically carry, the lawyers are required to physically carry the books to the court, lawyers used to come out with only relevant judgments. And now today you see the scenario. Today's scenario is that, you give at a click. Suppose you want judgments, say on old section 27 of the Indian Evidence Act. You push the button, you will get, starting with the great judgment of the Privy Council, which we often use, about 50 judgments of the Supreme Court on section 27 of the Indian Evidence Act, and hundreds of judgments of various high courts. Now what lawyers are doing is, they will go to the court and show 20 judgments on the same point. When there is direct judgment of the Supreme Court on the point which binds the court, or there is direct judgment of your own parent High Court, which binds the High Court, which binds the trial court or district court, whichever is that court. Now, because it is very easy to find out judgments, now lawyers go with 20, 25, 30 judgments on the same point. I remember one case which I give that example very often to the lawyers, especially lawyers conference. I think in 2007 or 8, I was dealing with appeals from orders under Order 43 Rule 1R. There are orders against the orders passed under applications under Order 39 Rule 1 and 2. So there was a case from a very important, a very prominent city in Maharashtra. And obviously, a very large, very valuable property was involved. Now, it was a very simple suit for specific performance of agreement to sell immovable property. Injunction was a very simple relief that defendant will not create any third-party rights in respect of the suit property and will not part with possession of the property. I realized that for arguing this application, the advocate for plaintiff had relied upon some 30 judgments and advocate for defendant had relied upon 31 judgments. 61 judgments cited before a poor civil judge for deciding application for temporary injunction. So when the case was called out and read the file, I told the lawyers that irrespective of the result, I am going to impose cost on both the sides. If you are forcing the judge to read 60 or more judgments by deciding a simple application for temporary injunction, the lawyers have to be penalized. So I indeed awarded cost to both the parties. I directed them to pay cost to the legal service authority. So tendency to cite large number of decisions is now on the rise. Maybe that members of the bar want to impress their clients and to show that how much study the lawyer has made. So therefore 50 judgments are cited, 60 judgments are cited. Now nobody is bothered about saving the court's time. Now there is one more area, especially in bigger cities. Now lawyers want to file written submissions. Now my experience is that lawyers argue 5 points, but while filing written submissions, they include some other 5 points also which are not argued. So therefore we started practice in Supreme Court, and whenever lawyer wants to file written submission, we used to say in the order, lawyer will file written submission not exceeding 5 pages, and it should be summary of submissions actually made before the court. So imagine the position of judges. You are throwing some 20-25 judgments at the judge. You argue for a long time, then you file written submissions running into some 35 pages, 40 pages. How the judges will decide the cases? So this is one area where saving the time of the court is so important. I went to National Judicial Academy. I believe it was in Hyderabad or Chennai or whatever, workshop of National Judicial Academy. So there was one district judge from one particular state, and later on I realized that in this situation of all states, he said, sir, when we hear civil appeal or a criminal appeal in sessions court or district court, there are some lawyers who start reading the entire appeal memo while arguing the appeal. So how do we control the lawyers? That was the question posed by the judges. Then when I discussed with my colleagues in various high courts, they said, sir, this is now common phenomenon. Now when you argue an appeal, is it necessary to read appeal memo? You must tell what are the facts, you must show the court what is the relevant evidence, and then comment upon how the court has gone wrong. But people believe in this. So I think now time has come for the members of the bar to understand the importance of time of the court. Time is so precious. There is one more area where we are being criticized. That is the area about holidays enjoyed by the courts and judges. Of course, I have my own personal views, and I will not share those personal views today because I could not convince my brother judges, brother sisters of Bombay High Court to take a different view. Now, first, let us talk about recently I read a criticism by the principal advisor, financial advisor of the Prime Minister about the holidays. Talking about our trial and district courts, I have experience of 2 high courts, 2 states, Karnataka and Bombay, Karnataka and Maharashtra. Now in these 2 states, perhaps judges get 4 Sundays as holidays and 2 Saturdays as holidays. People don't know that they have to spend at least 2 weekly offs, either in attending to the legal service authority function or attending to national local others. Nobody knows this. Now, of course, it's a point of debate whether High Court should have long vacation, Supreme Court should have vacation of 6 weeks. It's a matter of debate. But when we have debate on such things, that why Supreme Court works only on 190 days, we should also ascertain how many days the top courts in so-called developed countries are working. We will find that most of the courts don't work even for 100 and 110 days in a year. And someday, see, I am not here to defend long holidays, but someday, you see, it's a matter of making study. Now, Supreme Court reopens in the 2nd week of July or 1st week of July. Somebody must make a study and find out how many judgments are pronounced by the Supreme Court judges immediately after reopening of the judges and reopening of the vacation. Same thing happens in High Court. That how many judgments are pronounced. If you see that, you will realize that how much work is done by the judges in the vacation. But of course, it's a point of debate that when we have such a huge pendency, I said 4.77 crores cases pending in India. And of course, most of the states, trial court judges don't get holiday for 4 weeks in May vacation because criminal courts are functioning. In most of the states, trial court judges get 15 days, 2 weeks as vacation. But that is one area where we collectively as members of legal fraternity, the judges and members of the bar, we have to think about it because this is the perception of the common man that when you have such a huge pendency, you are taking long vacations. But as I said, there are 2 sides to it. Now there is one more area where we need to work. That is an area where the great quality which every lawyer must possess, quality of fairness, is disappearing. Maybe there are professional reasons, maybe there are many other reasons that the quality of fairness is disappearing. In fact, I always say that fairness and brevity are hallmarks of great advocacy. I remember there was a lawyer practicing in Mumbai, was had phenomenal knowledge in civil law and especially Rent Act matters, Tenancy Act matters, Agricultural Tenancy matters, Transfer of Property Act, and all basic civil laws. He used to have large number of first appeals and second appeals. So he carried a great reputation. His reputation was, when second appeal was heard for admission, if there was no case, he would not utter a single sentence and he would sit down. And his reputation was so great that whenever he used to utter even 2 sentences in support of his case, judges used to print substantial question of law and admit the second appeal. But that was enough signal. So qualities of fairness are disappearing. I remember, I give example of same lawyer. I was a law junior. I had not argued a second appeal. So my senior was unwell, so he telephoned me in the morning. He said that there is a second appeal in which he was appearing for respondent. So the file was kept in the court in his locker, so he go and read the file and argue the matter. I was actually perspiring. I hurriedly went through the file, but I recollected that it was some case under Hindu law, and there was a direct judgment of a British judge of 30s or 40s on the issue. They covered the case in my favor. So I went to the library, took that book with me. I was sitting, waiting for my turn. The same lawyer who I talked about his fairness was sitting next to me. He was anxiously looking at me. He said, "Are you going to argue this matter?" I said, "Yes, of course I am going to argue this matter, but sir, I have difficulty. My senior told me in the morning that I have to argue the matter, so I am going to it." So I was carrying that law report. So he said, "Young man, can I see this book?" Of course, he was a senior person, so I handed over the book to him. Then matter was called out. The lawyer got up. The judge had read the matter, just said, "Sir, this is the point involved." I was for the respondent. The senior lawyer said, "Sir, this issue is covered by a direct judgment of the High Court against me. And this young man has brought that citation also with him." So this was the fairness. When I came out of the court, he said, "You must have felt offended when I told you to give me the book." I said, "Sir, yes, of course I felt it. It was my trump card." He said, "No, my worry was whether you are carrying correct book and correct judgment." So these qualities of fairness, now they are fast disappearing in our system. Of course, it can be said both ways. Maybe there are some grievances about the behavior of some of the judges. It was always said that, judges used to be very dignified while dealing with the members of the bar, but even there is a change of approach on the part of some of the judges. So to some extent it is mutual, or it is some kind of a vicious circle. But therefore we need to work in these areas. Because I have always said on public platforms that judicial system in India in general, we always say in seminars and other functions that common man has great faith in our judiciary. But if you take a tour of our trial courts and district courts, you realize that that is half truth. People come to the court because they have no other option. So we don't carry exactly good image as a justice delivery system. And in many states it has happened. See, so long as a litigant feels that he has chance of securing justice within the four walls of a court hall, he'll keep on coming to the court. But someday he starts feeling that he will not get justice. And there are people sitting outside, there are politicians who try to run some kind of a parallel machinery. So people go there for quick justice. And see, ultimately, we have a constitution in place, we have a preamble, the preamble talks about justice. It's not justice which is delivered to court. Justice, social, economic and political. Now, unless we give a quality justice, we render quality justice through our courts, how can we say that we are compliant with our pledge which all citizens of India have taken under preamble to render social, economic and political justice to every citizen of the country. So therefore, now today time has come where actually bar and bench should rise to the occasion and ensure that the judiciary sails through the crisis of credibility. And there are other areas which I have commented upon in my judgment also. Now today we have a scenario where Chief Justice of High Court recommends a name for elevation to the High Court. That name is cleared by the Supreme Court, and the candidates have to wait, whose names are recommended, they have to wait for 9 months, 10 months, 11 months, and even more than that. Now the entire system of collegium works is on the website of the Supreme Court. When the case is set, when the proposals are sent to the Supreme Court, there is an IB report, there are remarks of the state, the Chief Minister and remarks of the central government, and after Supreme Court clears the names, why it should take time of 9 months and 10 months? Because those who are in power, they don't realize simple thing, that once there is a lawyer gives consent to become judge of the High Court, and once there is a resolution of Supreme Court published on the website that Supreme Court has recommended this man for appointment as a judge of the High Court, the workflow stops. How a person will survive? No litigant will come to a lawyer whose name is there on the Supreme Court website and he is being appointed as judge of the High Court. So this is also one area where we need to now. Yesterday I did a resolution of the Supreme Court Collegium. The central government had audacity to say that reconsider a proposal for transfer. This is the approach of the persons in power. This will amount to interference with the justice delivery system. We need very robust and independent judiciary. So there are problems and problems in judiciary. And what is happening is now, over the years, the profession has changed. I know that today we see very few voices of senior lawyers who rationally comment upon where we are going wrong. Or even there are few voices which say that something good is happening in the judiciary. Both ways. We don't see those voices at all. Maybe that now the profession has become more lucrative and nobody has time to express himself. So unless the members of the bar stand up and say what is right and what is wrong, the situation in judiciary will not improve, because there's a great responsibility of members of the bar. I remember as a junior lawyer in 1990, two very prominent bar associations, Bombay Bar Association and Advocates Association of Western India, is the oldest association of lawyers in India. They passed resolution, unanimous resolution, expressing doubt about integrity of certain sitting judges of the High Court. I mean, that was the courage of the members of the bar, that they raised that. There was a case in Bombay High Court where Chief Justice, at the instance of one party, transferred a very sensitive case away from a judge. So within 48 hours or 72 hours, members of the bar reacted. They called general body meeting. They protested. So this action on the part of the members of the bar is also missing. Ultimately, there are many things which judges can't do and can't say openly. But members of the bar are there. Members of the bar owe a responsibility to the system. So ultimately the solution, there is a problem. And I always believe that unless we accept that there is a problem, we can't find solutions. There is a problem. Now we have to deal with that problem. We must ensure that large number of posts of the civil judges and district judges are created. We must have proper infrastructure. It is also necessary now. Profession 30 years back or 40 years back when I joined, profession was different. Now today we need to give training to the young members of the bar. Training not only about the laws, but the skills of advocacy. What is the art of advocacy? We must train our young lawyers. Because we see approach of some of the young lawyers that they don't know the basics of art of advocacy. So there is need to train the younger generation of lawyers. They must know what is fairness. They must know what is advocacy. They must know that sometimes silence is best part of the advocacy. They must understand this. So therefore there is need to improve the standard of the bar. And see, there are many members of the bar or those who are outside the legal fraternity, they say that there are falling standards of the judiciary. The judiciary say 30 years back was more talented. There are falling standards. Now why there are falling standards? Of course, on public platforms I said yes, of course we must accept that there justification may be there in such criticism that there are falling standards. But then, who is going to improve the standards? Ultimately, those who are part of the judiciary, they come from the legal fraternity, they come from the lawyers. So it's not that maintaining high standard of our judiciary, only judiciary, the judges are responsible. The lawyers are also equally responsible. So today when we have completed 75 years of independence, now time has come when the members of the bar and lawyers must come together and they must ensure that our courts deliver better quality justice and we try and restore the faith of common man in the justice delivery system in India, and that can be done only by the joint efforts of the members of the bar and bench. There is much to be said on the topic. In fact, this topic will require days and days to discuss. But somewhere I could draw a line almost 6 o'clock. So I thank the President and members of the bar for giving me this opportunity. And I must say this, of course, at the end I must say this, that I always believe that as sitting judge, my judgments may have been wrong. Even my thought process may be wrong. But what was important today for me to share my experience, because I have experience of working as a judge of 3 different constitutional courts for almost 21 years and 9 months and working as member of the bar for 20 years. So this is reflection of my own thought process about what ails in the judiciary. There can be a point of debate about what I have said, but the whole idea of addressing you was to start a debate, to start a thinking process. So I am glad that the office bearers, the president, office bearers of the association have given me this opportunity. I thank them. I thank all of you for remaining present in our meeting. Especially when Diwali holidays are starting, I thank all of you for being here. Thank you. President says I must answer 2 questions. Anybody has any question?
I'm Dr. Suryapani Prashant, specialist in public prosecutor in the Telangana High Court. My question to your Lordship is that since one of the issues you have raised, your Lordship, is about infrastructure. How about a national infrastructure corporation which should be constituted under the supervision of the Supreme Court, which is independent of the government of the day, whether it is state or center, to look after funding and infrastructure requirements for the judiciary right from the district court to the Supreme Court?
See, I tell you one thing. This idea was already mooted. See, one thing we must remember, that no court has financial autonomy. Even if the judges say want to buy stationery, it needs budget approval. And what I feel is, please take this seat. What I feel is that this financial discipline is very important. Suppose tomorrow the government decides that we give power to the court to conduct tender process for construction of a building or for appointment of architect. We as judges are not equipped to conduct tender process. So it has to be done by the respective government, first come from the state government. But at the same time, national framework is required to define what should be the minimum infrastructure. So there has to be standardized infrastructure, because infrastructure different in different courts. In fact, one of the judgments of the Supreme Court has some effort to lay down what should be the ideal infrastructure. So such kind of idea will help to decide what should be the minimum infrastructure, so that there is some kind of a unanimity or homogeneity across India in different courts.
way out of upholding separation of powers. Kindly enlighten us on that.
See, one more, yes, you can continue.
Another question, as my lords has also pointed out about the matrimonial disputes. Other disputes also are in the line. So, can there be a better system of mediation and arbitration exclusively for family courts to lessen the burden of the regular courts? Thank you.
See, as far as first part is concerned, I have told you, I've been a judge for 20 years and 9 months. Personally, I have never experienced any interference in my working from any government, I must say that. So, things are not that bad. See, ultimately, we must also remember one thing. I am not on any party, political party, any executive, or any government, irrespective of the party. There is always a tendency to have more and more power. So, the only solution is that if members of the legal fraternity are strong, the judges and members of the bar, the political establishment will not dare to interfere with our affairs. So that's the solution, because I am not on a party. Every party will have that tendency. Now about this mediation and conciliation. See, mediation in India, we are lagging far behind. Because, sometimes it becomes a ritual, mediation. So in true sense, if there is mediation, we will be able to settle a number of matrimonial disputes. And today, we have a scenario when, I said to the Chief Justice that don't send any matters which are already settled to Lok Adalat mediation, just to show successful resolution. So we need to work on, because there are proper mediation processes. I think we will be able to substantially reduce the matrimonial litigation. Not only matrimonial litigation. Now, there are typical litigations which, more than any principle, the individual egos are involved. For example, a dispute, family dispute over property, dispute between brothers or sisters, or dispute between two partners of a partnership firm. They are all because of personal egos or personal misunderstanding. Those cases are ideal cases for mediation and conciliation, but that is not happening.
The question regarding the appointment of the judges to the High Court, the Lordship is aware, as per our Constitution, 10 years practice as an advocate is a qualification to be appointed as a judge of the High Court. But as per the MOP, your Lordship, it says after 45 years you have to be appointed as a judge. Then after eventually when actual appointment is happening, it is after 50 or so. By the time the judge retires, he has only hardly 10 years or less than that. Is it that do we need to change the MOP and bring in so that judges who are talented, advocates who are talented, and the ones who are hardworking and all that take appointments to them?
See, actually, there is no absolute bar on recommending name of a lawyer whose age is less than 45. There is no bar. But of course, normal procedures are followed in extraordinary cases. There are instances where a person who is less than 45 has been appointed as judge of the High Court. And later way, I have to support this because I was appointed at the age of 45. You want to?
What would be how to understand the moment the judges of Honorable Supreme Court or High Court retires, they occupy the positions in the Rajya Sabha or the government or various other. How to contain this and how we have to respect these things. See, number two, next, number two. There are honorable judges who have been transferred from one court to another high court on the reason of administration of justice. But it obviously shows that due to the corrupt practice, huge corruption, and has been transferred. Would it solve the issue, or the moment can't we see that a judge once sees a corrupt transfer from one court to another high court, would he continue or stop making such a corrupt practice? And what are the serious steps have been taken by the Honorable Supreme Court as a collegium, or is there any debate on that? Merely transferring, we strongly feel that it is not a solution. But in the same way, the trial court also district court the same thing. The judge is subjected to suspension, but there is no such a mechanism of a review of the judgment for which he has been elected. Please have it.
First point is as far as I am concerned, I am very clear. No judge of the Supreme Court after retirement should accept office like MP, governor, or any other office. I am very clear about that. The second part about a transfer is very dicey issue. See, there are many who say that, why don't you initiate proceedings against the judges of the High Court? It's a very dicey issue. It has direct connection to the independence of judiciary. As High Court judges, we deal with very sensitive cases, and we have to decide without fear or favor. If judges are to be subjected to some proceedings very often, will they be able to decide without fear or favor? That's number one. Number two, that's a perception that some cases, some judges are transferred because of allegations, as you said. We have to find out better solutions that is to be done in such cases. And then you are right, that criticism is there that because Supreme Court collegium feels that there is allegations of corruption, we should be sent to other court. We need to find out solutions on this. This is one. And secondly, of course, every member of the bar has a right to say that there is something wrong with integrity of a judge. But ultimately, job of a judge is such that he can't please everybody. At least he should not attempt to please everybody. He has to offend one party. He can't decide in favor of both the parties. So these are the things we have to balance. But of course, I really see a point in your sentiment that what is the use of transfer. But on that, we have to find out better solution. And for which, of course, discussion is required, and there is such discussion which goes on. But we have to find out solutions within the framework of constitution.
In view of high rising of matrimonial disputes and pending before different forums like DVC matters in state courts, matrimonial and restitutional issues pending before family courts, and other issues pending before appeals like that. Prevent all these issues and to prevent the burden on the courts also, is there any possibility to any suggestions to bring all the matrimonial issues to bring out to one court and thereafter only to appeal or regional court?
There is no clarity in the statute. For example, I have not dealt with the new courts and therefore I am referring to old courts. So, section 125 of CRPC, the family court act says that family court judge can deal with 125. It can be clubbed with the matrimonial matter. But there is no clarity in the statute about the domestic violence act. So, where there are family courts, we find that family court deals with matrimonial dispute and 125 or maintenance of custody matters. But the domestic violence cases continue before the magistrate. So we need to have amendment. That is number one. Number two, someday we need to also discuss the success or failures of family court after family court act has come into force. Whether family court has really helped to resolve the matrimonial disputes very quickly and expeditiously. On that also debate is required. And you are right, ideally the statute must provide that all matters arising out of matrimonial dispute, they should be under one umbrella, in one code. But of course, there are difficulties there because, say, for example, 498A, the allegations are against all members of the family, not only spouses. But surely, there is a point in what to say.
Sir, I would like to ask only one point with regards to, during the lecture you had mentioned that in the 80s and 90s, the Bombay High Court Association as well as the West India Association, they used to have a spine, used to be able to speak against what is wrong and also speak about what is right. But today, do you think there is also a role which is being played by the Bar Council as well as the Supreme Court in silencing the voice of the advocates and the bar associations whenever they have any issues, be it issues with regards to the integrity of the judges or issues with regards to advocates themselves? Especially in Telangana, over the last few months, last 1 year, 2 years, we've seen several advocates who have been murdered, brutally murdered in daylight by clients, by other side clients. Several such occasions have happened and several protests were raised by the advocates. Several calls for strikes and boycotts have also been raised by the advocates all across Telangana, all across the district courts as well as by the High Court. But the Supreme Court repeatedly tells that advocates do not have a right to strike, advocates cannot protest. Even the Bar Council also sings the same line. Is there anything we can do to go back to 80s, go back to 90s where advocates have a spine?
I'm glad you asked this question. Please read the last speech of Dr. Babasaheb Ambedkar in Constituent Assembly on 25th of November 1949. Unfortunately, we have quoted it. Dr. Ambedkar said that after we have a constitution, illegal means of protest must be abandoned. And therefore, there is a judgment of the there are two judgments of the Supreme Court. If lawyers boycott the court, that amounts to criminal contempt. And I want to give you a reason. Now take a case of a district court. On a particular day in district court, if you take about 27, 28 or 30 courts there may be 5,000 cases listed on that day. If lawyers boycott the court, in 5,000 cases dates are given. So ultimately who is affected? Litigant is affected. There are other means of protest available to the bar. Boycott is not the only weapon available, and by boycotting the court, not only that it is a criminal contempt, I tell you a practical reason. Boycotting the court, you are doing great injustice to the litigant. What is the fault of litigant? Litigant has no, it's not a fault of litigant. Imagine 5,000 cases listed in a particular court, lawyers are on boycott. Lawyers go back. In all 5,000 cases, dates are given. Who is the sufferer? That is number one. Number two, your grievance about murders of the advocate, for which actually there has to be a law. Like doctors are demanding a legislation for protecting them for incidents of violence in clinics and hospitals of doctors. There has to be a law. But lawyers cannot hold litigants for ransom because they have certain grievances. So please remember this, and therefore there is a law laid down that lawyers cannot boycott the courts and it is a criminal contempt. The only reason is that lawyers and judges exist for litigants. If they have grievances, there are other methods available. About the lighter vein, I will answer your question that whether lawyers lack spine. In lighter vein, I will say spine is already there with every lawyer. The question is whether we are using that spine. That's the question.
Thank you. Oh, so.
Minimizing the arguments and minimizing the arguments of the advocates by saying that the court has its very patience. But sometimes also this is key. Right? Sometimes judges are saying court time is precious, but you are asking for two times. All time also very precious. You come to next day and to protect the rights of others. And human rights are protected from so that is not happening kindly. Focus on that.
Yes.
Thank you, my dear sister and brothers, senior advocates, to make this celebrate this moment as a process success. Now, I request my secretary, to address the vote of thanks. Respected Honorable Former Judge of the Supreme Court of India, Honorable Judges of Telangana High Court, esteemed dignitaries, senior members of the bar, learned colleagues, ladies and gentlemen. It is indeed a great honor and privilege for me on behalf of our esteemed Telangana High Court Advocates Association to propose this vote of thanks on this momentous occasion. At the outset, I extend our heartfelt gratitude to the Honorable Sri Justice Abhay S. Kota Garu, former Judge of the Supreme Court of India, for gracing this event and delivering such an enlightening and thought-provoking lecture on the topic problems the judiciary is presently facing and solution to cure it. Your Lordship words have not only highlighted the challenges but also shown us the path forward with wisdom and optimism. I also take this opportunity to express our sincere thanks to Honorable Judges Sri Justice Shamkosh Garu and Srimati Justice Nanda Garu and Honorable Judges of Telangana, who have always been supportive of the initiatives of our association. A special note of appreciation is due to our President Jagan Garu and our Executive Committee of Telangana High Court Advocates Association for organizing this distinguished lecture and for their constant efforts in promoting intellectual engagement within the legal fraternity. I also thank all the learned advocates, law officers and members of the media for their gracious presence and participation, which made this event meaningful and successful. Once again, on behalf of the Telangana High Court Advocates Association, I extend our deepest gratitude to the Honorable Sri Justice Abhay S. Kota Garu for sharing invaluable thoughts with us and for inspiring renewed commitment towards strengthening our judiciary. Thank you and all. I request all the Honorable Judges and members to stand for high.
ठीक है।